12 o'clock, so why don't we get things going? People will be joining us, and that's fine. First of all, thank you to everybody who did join us today. It's a pleasure to do this webinar, and it's on a very important subject that has impact possibly on a lot of people, and that is granting blanket legal immunity. Again, I'm Chris Sundberg, Executive Director of Elder Voice Family Advocates. First of all, our speakers will cover what's in the bill right now and discuss how it threatens the families to pursue legal action for wrongdoing, both in long-term care and other businesses. First to speak will be Joel Carlson. Joel was a former Minnesota House of Representatives member before he established his legal research and government affairs firm. He has represented the Minnesota Association for Justice since 1994. That's one of many clients that he has. And I can tell you he's one of the most talented lobbyists out there today. Following Joel will be Suzanne Scheller. And as most of you know, she's the founder of Elder Voice. She's also our legal advisor and expert elder law attorney. Susie is an award-winning attorney and a frequent author and speaker of elder abuse and elder law issues. And she's a passionate advocate and an invaluable member of the Elder Voice family. After they give their comments, we'll open up for questions. But as questions occur to you, just use the chat feature at the bottom of the screen to post your questions, and then we'll address that at the end. And also just a reminder, please mute yourself while our speakers are talking about their issues. And with that, I'll turn it over to Joel. Thank you, Joel.
All right. Thank you, Chris, and welcome everyone. I'm Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I've long represented the Minnesota Association for Justice at the Capitol. We used to be called the Trial Lawyers, but we changed our name about 12 years ago because what we really do represent is justice. And our members, we've got about 900 members across the state, many of whom represent family members who have been injured through the wrongful acts of others, including those in medical facilities and long-term care facilities. So the issues that I've been so happy to work with Chris and Suzanne over are very dear to my heart and to our organization. Being able to work with other voices at the Capitol has been a pleasure for me, because I have to tell you, in all sincerity, being a voice for victims against the onslaught of nursing homes and long-term care facilities is not an easy task. And without you and your stories and the message that you bring about patient safety and accountability, we couldn't do what we do at the Capitol. And so I really applaud Elder Voices and all of you for your efforts to help the most vulnerable among us. Before I begin my comments about the bill, the way we're going to break this up, I'm just going to talk to you a little bit about the politics of where this legislation is at, where it comes from, who's asking for it, and then Suzanne is going to get into more of the details of this legislation. But on the onset, I want you to know that we all recognize what a problem the pandemic is for everyone. We're not applauding for litigation. We're not saying and wanting to have people rush to the courthouse, but that doesn't mean that we want to give up our constitutional legal rights to a remedy and our rights to a trial by jury. And the bill that we're going to talk about, Senate File 745, is the most extreme and outrageous breach of our constitutional rights that I've seen in my now 40 years at the Capitol. And Chris said I was a former legislator. That was before electricity. I've been a lobbyist a lot longer than I was ever in the legislature. But I have to tell you, every time there is a crisis, every time there is emergency, the business community, the insurance federation, and hospitals and medical providers all come to the Capitol seeking protection from the government for their wrongful conduct. And this one is the most egregious. And we have to oppose it, and we have to oppose it strongly. We disagree with all of the reasons that are being advanced to pass this legislation, but one of the things we disagree with the most is the idea that other states are doing this. If Minnesota cared what other states are doing, Suzanne and I and Chris know that we would have long ago repealed our horrible statute on survivorship, of which every other state in the country provides something, some measure of accountability when someone dies and their case dies with them under Minnesota Statute 57302. If we cared what other states did, we would have long ago repealed that statute, but they fight tooth and nail to prevent us from doing that. So we don't really care what other states do, but if you really drill down on that and look at what other states have done, number one, no one has done anything as extreme as Senate File 745. And number two, many of them have simply restated the law. This is your standard of care. When you breach your standard of care, you're subject to accountability. If they brought a bill forward, I think that we wouldn't be having this, that did that, I don't think we'd be having this seminar. But this is a live wire. It's pushed by very powerful interests at the Capitol. And that's why we are investing the time and energy and effort to oppose it at the Capitol. One of the reasons that they promote for advancing this bill is the flood of litigation that is going to hit Minnesota. You need to know that across the country, there have been about 9,000 cases filed related to COVID-19. And there is a law firm that is tracking all COVID-19 related litigation that specifically mentions COVID. And there are about 9,000 cases. About 200 of them are from consumers. The overwhelming vast majority of cases are filed against businesses, against their suppliers, against the government, and against their insurance companies. And, you know, to us, what they're doing at the Capitol is saying, do as we say, not as we sue. They want to protect their access to the courthouse, but they do not want to be held accountable by consumers when their negligent acts have caused injury and harm to our loved ones. So the idea that runaway litigation is driving this legislation is absolutely untrue. Not a single case has been filed in Minnesota, not a single case for malpractice, for transmission, for wrongful death, conditions of employment, medical malpractice, not a single case. Everything that this bill encompasses has not happened once in Minnesota. So we are very much opposed to this. It's unneeded and unnecessary, but more importantly, it's dangerous. It's dangerous because when you eliminate the level of accountability for people to treat you with an appropriate standard of care, as we've seen in New York, we know that they will cease to act responsibly. And that's why this is so dangerous for legislation. The last thing I'm going to say about the bill before we turn it over to Suzanne, and then I'll put up the bill so she can kind of walk through it for you. I've been at the Capitol a long time, and I've worked on legislation that has been written, and legislation that has been passed that retroactively has been passed to provide accountability for people for their wrongful conduct that wasn't known. There was a big period of time when people were getting blood transfusions that were tainted with the HIV virus, and the people knew it and they didn't, it was concealed and they didn't tell people. We've had legislation to help victims who have been subject to sexual abuse in the past by clergy and others, and we've made that retroactive. We have bills for defective seatbelts that have been made retroactive. We have never once in our state provided immunity to people for their for-profit conduct, and we've never once, like this bill does, we've never once provided retroactive immunity for someone's wrongful conduct. This bill is retroactive to March 13th of 2020, the day of the first executive order from Governor Walz. They want to say that anything they did during that entire period of time, no matter how egregious, is going to be now immunized by the legislature. We've never done that, and I hope we never do. So with that, I'm going to turn it over to Suzanne. And then I think when we're done, we might talk a little bit about advocacy and what, and what elder voices and others can do to make sure their legislators know how dangerous this bill is and how we can get our voice heard in that way so that this doesn't become law. So Suzanne, I'll turn it over to you, and thank you again for having me here.
Thank you so much, Joel. I appreciate it. And thank you for your comments related to the applauding the efforts of those on this call and those within Elder Voice Family Advocates for allowing your voice to be heard and your stories to be told. And they are very significant, and it is not taken lightly. So again, thank you. Joel has laid out some of the history of the legislation. Joel, if you want to go ahead and share the screen, what we're going to show you is the language of the legislation. I'm going to walk through some pieces of it, and then I'm also going to talk about what would happen if we had no legislation in some of the issues and concerns that have arose, meaning how would Minnesota deal with these situations. So one of the things to note is that the first section highlights several definitions: essential business, first responder. You'll note if you go down a little bit to the bottom, healthcare facility does mean nursing homes, clinics, hospice. So it would encompass this, assisted living, home care, we believe, as well. And then we have personal protective equipment. A person, notably, is any individual, association, for-profit or nonprofit entity, organization, or otherwise. And then if we before, when we define business, we were looking at any owner as well. So we believe these definitions definitely include healthcare facilities, including nursing homes, assisted living, and home care. And as we know, in the area of long-term care, there are multiple healthcare providers that come together that we believe are all included and encompassed in this bill. So in subdivision 2, it's limiting liability related to designing and manufacturing, labeling, selling, distributing, or donating products in response to COVID. And from the outset, it seems reasonable. We all rolled up our sleeves, right, and contributed towards making masks and trying to make alternatives to personal protective equipment in order to accommodate the infection control standards that that were put forth. But what you need to notice is, again, as Joel had said, it says that a business shall not be liable in a civil action alleging any act or omission arising out of or relating to the administration or use of a qualified product. One thing to note, and this is a big theme in this, is our law already protects these issues. And secondly, our law is flexible enough to accommodate the particular use. And so we do not have an issue here in our law related to reasonable use and reasonable production of a product that is used during this time. What we are trying to prevent, and why we're opposing this provision, is that if someone manufactures something knowing it's defective and others are injured, our law has said that we are able to go before a jury, argue that case, and determine if there is liability based on that defect. Now, people who use products that are defective, not knowing they're defective, are already protected under our law. That is not meeting the definition of negligence under our law to use a product that you don't know is defective in some way. So again, this is broad, and it's sweeping in what we would consider bad faith actors, and we're trying to ensure that we're able to hold those accountable. If we can go down further then, Joel, this is all about product liability in the first part. There is a minimum injury requirement in section 2. So a person is prohibited from filing a civil action for injury, damage, or death, or economic loss related to COVID. And again, in my opinion, that term related to COVID is very significant. It's not saying exposure to COVID. This is not, some of the other states' bills are specific as to COVID exposure. This is broader than that. Related to COVID is the frequent phrase used throughout the bill. unless that person is diagnosed with COVID-19. So they need to have been diagnosed and have some type of minimum injury. Again, this goes against our Constitution. We believe that these exceptions that they're putting in here essentially eviscerate a lot of the provisions from being utilized in the first place. This, for instance, has some unclear language related to being diagnosed with COVID and the hospitalization or experiencing serious illness or death. There's some lack of clarity here that we're also concerned about. The exception that I want to note is the section does not apply to acts or omissions committed with intent to cause harm. Again, the intent requirement is really a criminal threshold. It's a high hurdle. It's a high threshold. In our law, intent is, as you can imagine, it would be defined. And that is defined as an actor desiring to cause the consequences of his act. And so most of our healthcare providers, we have many good healthcare providers, and most of our individuals and healthcare providers are not operating with an intent. So the exception really does not save it, is the point. Let's continue forward.
I'm working on it.
Okay,
There
sounds
we go.
good. Section 3 is limiting liability. Again, limited liability. It's again saying that an owner and has many terms is not liable for injury, damage, death, or economic loss related to COVID unless the owner or occupant acts in a willful, wanton, reckless manner, intentionally causes the person to be exposed or to contract COVID. There is exposure language there. However, up above, it's a broader related to COVID language, or intentionally causes the person to, that intent, willful, wanton idea is in here. These terms that are intended to be exceptions are extremely high hurdles in the law. So again, we believe this would have a difficulty from the first phrase related to COVID for all owners. I want to take a moment to talk about how a normal case would work in Minnesota, because it is on point to what we're seeing here. In a normal case of negligence in Minnesota, you would have to meet, if you were bringing a claim of negligence against any individual, entity, or healthcare provider or nursing home, you would have to establish that they had a duty to do something. The duty is established based on multiple factors. And if we have time, I will go into it more, but you have to establish the duty to do something, that there was a breach of that duty, a breach of standard of care, that breach was a cause of the injury, and that there was injury. So that's all negligence claims, regardless of who you're bringing the claim against. What we want to stress here is, again, in our really well-established law, and I am meaning from the 1900s on, we have had well-established law related to a person needing to meet the elements. Our law is intended to try to have an avenue for accountability for harm. It has hurdles that must be met. All 4 elements must be met. You can be out on any of the elements, including not creating a duty, not breaching a duty, not having that breach be a cause of the injury, and perhaps not resulting in injury, period. So that is our current law. If we did nothing here, we are believing that that flexibility and that well-established tort law will weed out, essentially, will accomplish the effect of not having a good actor held liable for their acts, or proposed acts, or alleged acts, if you will. So I just wanted to take a moment on the liability section to explain how our law currently works. And I would also note that if it's a claim against a medical provider, there are additional hurdles that are unique to Minnesota, in that we have to get an expert giving an opinion, a nurse and or doctor stating that negligence has occurred. They have to say what was the standard of care during COVID in a nursing home in Minnesota, and was there a breach of that standard of care that is developed not just by established regulations, but by the circumstances of the day, the guidance, the regulations, the laws, the circumstances So a peer, a medical peer, is establishing what that standard of care is and whether or not there was a breach of that standard of care. Again, unique to Minnesota, we cannot even bring the claim unless we have those medical opinions. So we believe our law accommodates for what we're trying to do here in establishing a standard of care during COVID.
Suzanne, can I interject one thing here?
Yes.
This section that she's talking about relative to willful, wanton, and reckless conduct or intentional conduct, those are important buzzwords that the insurance industry uses at the Capitol frequently, and I'll tell you why. Intentional conduct is not covered by insurance. And so that language, if that's what you have to prove, even if you were successful, your ability to recover against the negligent party's insurance is eliminated because all of their insurance policies are not going to cover willful, wanton, or intentional conduct. That's not an accident that that language is in there. And we see this particularly on claims against the government. And we just had a case that was handed down by the Supreme Court relative to an off-duty officer. If an officer acts in an intentional, willful, or wanton way, they lose the ability to even be defended by the municipality. And so this language is not there by accident. They would bring a motion at summary judgment that it was intentional, and they would cease to defend the person or have any liability for a claim if you were successful. That is why that language is so dangerous from our association's perspective.
Yeah, thank you for interjecting that. It really, again, pushes it into the akin to a criminal act, and insurance does not cover criminal acts. It really takes it out of the notion that the acts of an employee, the employer is liable for the acts of their employee when in the scope of duty. So what they're trying to do is separate out the scope of duty of the individual and say, no, they were acting on their own. They weren't acting as my employee. They were acting on their own. So it exposes employees to some extent, depending on the circumstances here.
Right.
We can go down further.
You want to talk about safe harbor?
We'll talk about it a little bit, and here's the way we'll talk about it. So this is saying that if you follow the guidance, then, which includes recommendations, policies, procedures, regulations, executive orders, if you follow that guidance, you're not liable in a civil action for injury, damage, death, economic loss related to COVID. And one of the issues that we believe is important here is when you look at administrative law as a whole, rulemaking is, the court has said we're going to give deference to an administrative agency. So I get my main point here is we give a tremendous amount of deference to administrative agencies, but the rulemaking has been deferred in court cases and the manuals they create internally. But the guidance has not specifically been determined how the court should treat that. But what I want, because of the deference that agencies are given prior to, it is appropriate that we try to follow guidance. But this is such a low threshold. It's unnecessary, I guess is my point, because really all the guidance has said, make a COVID preparedness plan. That's a main issue of what they've said. Each entity, business, restaurant, nursing home, make a COVID preparedness plan. And so if you have that, supposedly, you're protected, but that doesn't mean it was carried out. It doesn't mean there's other acts that would have caused injury within that. So in effect, it's unnecessary because we already give deference to these guidance as part of a standard of care. And number two, it should not be simply because you have posted a particular plan and there's an injury that's caused over here that actually might not have anything to do with COVID exposure, but the defendant argues that it's related to COVID, that would be immune. So a note about that.
Right, and this also is something that the business community pushes in the environmental field and others, where they're trying to say, if I complied with guidance, I am not liable in any civil case. And those are usually not successful at the Capitol. We agree that they would absolutely have a justifiable defense that they followed guidance. But this makes that guidance an immunity and not a defense.
Mm-hmm.
And they absolutely have that as a defense right now. This turns it into an immunity. And it doesn't, they don't, if you look on line 4.22, they don't even really have to comply with it. They just have to say they acted consistent with it. If I was supposed to wipe something down with a disinfectant wipe, but I instead used just a wet cloth, that was consistent with the guidance. And so you can't hold me accountable because I was consistent with it. This is a really dangerous provision to turn that defense into an immunity.
Well, and what it does too, as Joel pointed out, it really creates it really creates a carte blanche bar. Immunity, that's what it does. It creates a bar to a claim, but it is unusual to have the bar simply be that you have a statement somewhere or that you have said, I followed guidance. On our side of the case, we are not able to say, simply because there was a regulation from the federal government or the state government, and you didn't follow it, you were negligent. We are not able to say that on the plaintiff's side. And this would essentially be saying the defense could do that and more on the other side. So again, it comes back to what is the standard of care. And so what I want to do is talk a little bit more about what in Minnesota law says the standard of care is, because that's really what it's coming down to, and how we in our law accommodate that. Standard of care can be established by statutes. As a piece of that, can be established by regulations and rules, agency manuals, agency guidance. But it also can be established by items that are not in law. The standard is, what would a reasonably prudent person or entity in the same or similar circumstances have done? What would a reasonably prudent person or entity, a reasonable nursing home, a reasonable assisted living, a reasonable restaurant owner, a reasonable person have done in the same or similar circumstances? And in the absence of established law, we can create that standard of care. So again, we believe that the current circumstances would be factored in. There are two different types of breach of duty. One is under common law and the other would be under a statutory provision. And I just referred to that. We do not have statutory provisions at issue here that would create what we call negligence per se, where you have a statute that says, if you didn't do this, you are negligent automatically. We don't have that situation here. So we're needing to create and argue and support the standard of care, and we're not trying to react or respond to any law that automatically would create somebody liable in these situations. Again, the injury, the breach must have been the proximate cause of the injury. That would be difficult to meet that standard in some of these cases, to be quite honest, because COVID is, as we know, has had a prolific spread rate, and how it spread, we find challenging to determine. So I am trying to show you how our law protects us at this point in time without the immunity provisions. So I want to give you a few particular examples as well of things we've become aware of related to nursing homes where this immunity bill could prevent such claims. And they're not exposure to COVID claims. Those are frankly challenging claims, as I've mentioned, because of the prolific spread of the disease. But if something happens during the time of COVID, that is what this bill sweeps in and causes that conduct to be immune as well. Something happens during the time of COVID. You just happen to have it happen on March 14th instead of March 12th. And you are now not able to bring that suit. That's the type of unfairness that we're seeing, the inability to exert your constitutional right. For example, if a care plan in a nursing home calls for a person to be transferred with a Hoyer lift and 2 individuals, and we have a situation where only 1 individual was present and the Hoyer lift transfer did not go well, and the person was dropped from the Hoyer lift, fell, hit their head, had a subdural hematoma, and died. That has nothing to do with COVID exposure. They were not diagnosed with COVID related to the minimum injury requirements in this bill. And we would look to perhaps seek accountability and bring a claim for a breach of a standard of care. Standard of care being a Hoyer lift with the assistance of 2 staff members, and only one was present. It caused injury. In fact, it caused death. However, because of this bill, what we would anticipate is the defendant would attempt to throw and dismiss the case because they would say that the staff member, the second staff member, was not available related to COVID, that they were short-staffed, that they did not have the proper individuals. And these are challenging issues, to be sure, but what we believe is this language can operate as an absolute bar to if we didn't even bring a claim that is associated with COVID, but yet the defendant came in and said that the circumstances were related to COVID and therefore no claim is able to be brought. Again, it's a constitutional right to seek redress for injury. That's one example. Another might be pressure sores. We have heard difficult stories about those in assisted living and nursing home developing pressure sores on the coccyx. A large size of this on their back. The back is not a normal place to get a pressure sore. It has to happen if you're completely lying flat or in some pressure point on the back without turning and repositioning for an extensive period of time. And so we're seeing claims of that nature that come through where there's simply not having minimum cares performed and they're developing pressure sores. Similarly, we believe this legislation would bar such claims. If it didn't bar it from the bringing of the claim, it would bar it and dismiss it based on the defenses brought up in the claim. Those are 2 examples of cases that we have heard of. There are multiple other cases that we've heard of related to simple neglect, not getting water, not getting food, not getting basic hygiene, not to mention the abuse considerations that we believe may be a tip of the iceberg based on what we're hearing at this point in time. So it does have us greatly concerned, number one, that a person would not have the ability to exercise their constitutional right to redress. And number 2, that the language is extensively broad to prevent claims and sweep in claims that are not due to COVID exposure and COVID infection. The other thing I want to highlight is that there's often a question of employees. This bill would also prevent the employee from bringing claim against their employer for knowingly, for putting them at risk, for harm. And so that is something that we don't want to be lost in this language as well. There is workers' compensation for those who are employed in Minnesota. To get any damages beyond workers' compensation is already a fairly high hurdle in Minnesota for an employee claim of injury against the employer. And so, but this would prevent the claim. And we also note that if someone came from outside of Minnesota through a third-party contract company as an employee, for instance, they may not be protected at all because they would not be under Minnesota workers' comp law. So we want to make sure that the employee discussion is factored in to this language as well. I'm going to pause, Joel, and ask for you to, one more thing on retroactivity, and then I'll ask Joel for his additional comments too. As to retroactive activity, what is most concerning, that is a bedrock principle of our law, that we would be given notice of what may happen. That's tried and true, very important principle, that the law provides notice of what would happen. That's why the retroactivity date is so concerning, because we are hearing from many who have loved ones in facilities who may have made a different decision had they known that there would be no accountability for harm from March 13th forward. And that violates our policies, it violates our history in our law. And it did not allow families the ability to make decisions in real time related to their loved one. So that is a factor here as well. Joel, what else do we want to make sure and cover?
Well, a couple things, and I think that last point you made, Suzanne, is absolutely critical for us to remember. When you're a vulnerable adult, you have three ways to protect yourself. You can have frequent visits from family. You can have regulations and regulators do inspections and try and protect you, and you can hold people accountable in court. We know that family visits were not allowed during this time. We know that regulators were not able to do as much as they could, and in a lot of facilities, they're not even licensed yet. So there is no regulatory oversight. And this takes away our final bit of accountability. This eliminates your ability to hold them accountable in court. And the last point that Suzanne made on our constitutional right, and everyone thinks about our right to a trial by jury, and you hear a lot about the Second Amendment and guns, but you really don't hear that much about our Seventh Amendment right to a trial by jury. But you forget that that was the second plank in our petition to the king for our freedom. Taxation without representation and our right to trial by jury. This completely eliminates your ability to go to court to hold someone accountable. And I was going to talk a little bit about what we can do about it. Number one, we need to let legislators know. And I just put up in the chat a district finder where you can enter in your zip code if you don't know who your House member is. We're not all super educated like Mr. Mullery on the call here, and not everybody engages with their legislators all the time, and Joe was a great one. But find out who they are and communicate with them. Tell them how bad this bill is for average Minnesotans. It protects corporations for their wrongful conduct at the expense of Minnesotans and their constitutional rights. So that's number one. We really need to not let our guard down in letting people know about this bill, because even though it didn't meet a deadline in the House, deadlines, bills being dead at the Capitol just means that they're slightly less alive, right? They can come back at any point, and whether it's in a conference committee or a final agreement with the Senate Republican majority pushing for this bill. It's an important issue for them and the business community. It could surface at any time. So we can't let our guard down and not take the step to communicate with our legislators about how problematic this is. The other thing that I believe is helpful is just talking to your friends and family about this. There's a bill at the Capitol that protects everybody for anything that happened during COVID. That's a bad idea. Nationally, our association has been doing polling, and I can tell you that granting this type of immunity is unpopular with the public, but it's only unpopular when they know about it. So it's really important that we just don't, it's really important that we don't ignore the need to protect our legal rights, because really that is one of the only ways we can defend ourselves. And it frustrates me to no end when I talk to Suzanne and she's got a case from a nursing home resident who has died from something unrelated to the injury they sustained, and she can't bring that case forward because we have a law that precludes it. This would be survivorship on steroids. It would bar everybody's claim, and that's what we can't allow to happen.
Yeah, and I just wanted to expound on that. Again, Minnesota in 573.01 starts with claims don't survive after the death of a person. We've carved out some exceptions, but we frequently come up against the issue of a person in a long-term care facility who has multiple diagnoses, maybe advanced in age. They may be injured, but if they die of unrelated causes, the claim essentially goes away, and you cannot collect pain and suffering damages on behalf of a person who actually does die from the negligence. So we have a lack of survivorship, but we also have a lack of survivorship of the damages. So we are already, if you list the hurdles and challenges to bringing some of these claims, they are fairly numerous. So we're already, compared to other states, finding it more difficult to bring some of these claims. And so again, that would be when he says lack of survivorship on steroids. We have few options to seek that redress, and this takes away the few.
The one of the questions in the chat, I think, was to everyone, and I'll just let you know, Senator Dibble, both for Elder Voices and on these consumer related issues, is just 100% champion. I kind of divide people into three categories: saints, sinners, and savable. And Senator Dibble is a saint, as well as Representative Hornstein. I'm not worried about where either of those two are at on legislation like this. But there are a lot of people in the savable category that we need to convert to saints, and that's how I approach them. And I ignore the sinners. We're not going to change their mind. They're not going to come over to the right side. About the only thing I've seen change people's minds is when they have a family member who is unfortunately a victim of someone's bad conduct and they need to see a lawyer. That's about the only thing I've ever seen change a legislator's mind.
Well, with that, thank you very much, Joel and Susie, for your very enlightening discussion here. Why don't we open this up to questions for everybody? And before we do that, though, I do want to thank the many folks here that have already contacted their legislators and sometimes have forwarded what kind of response they got from them. This is very helpful information for us, and it helps us to fill in the holes where we need to, because we cannot allow this bill to be passed. With that, you can ask a question, just unmute yourself, and you will be able to direct your question to Susie or Joel. Anybody have a question at this point?
I have a question.
Go ahead, sir.
Go ahead, Elon, go ahead.
So my question has to do with staffing level. I anticipate this to be a gray area, and also goes back to the language of related, right? The related that you kind of emphasized, Susie, earlier. So a lot of things could be supposedly attributed. A lot of failures in care and injuries and death during the pandemic could be attributed to COVID, when providers may not be forthcoming about the fact that we know that half of nursing homes in America had low staffing levels prior to the pandemic, and at least one quarter been found to have dangerous staffing levels. And things may be even worse in assisted living residences. So it goes back a little bit to your example with the Hoyer lift. You can blame everything about COVID, and you can always say, oh, it was the low staffing level that were caused because COVID, when in fact you had poor staffing levels prior, especially in settings such as assisted living, when it's not being tracked as it is being tracked in nursing homes, at least prior to the waivers of CMS with the payroll-based journal system. So just kind of your thoughts about that.
Yeah, I will say something, and Joel, you can add if you want. The whole idea of the reality of short staffing, you're right. The short staffing was an issue prior to COVID. And how does that come into play during COVID? They're able to make that defense. That's what we're ultimately saying. Allow us to bring the claim. We abide by what the jury decides, but let us make the case. And then someone will decide that. We would prevent facts and circumstances. We are a case law country. We're not a civil law country, meaning we don't have something that says you can't do this or you have to do this. We based our decisions on the facts and circumstances of every case. And that's where those facts and circumstances would come into play. Were you making every effort to get staff, and were you making every effort or reasonable efforts in infection control, but one day you had all these staff gone? Those are going to be facts and circumstances that they can defend on, we can make arguments on. But again, we have the right to bring the claim, present the evidence, hear the defenses, and make a decision. In
thank
fact,
you,
and we
Susan.
all know that some of those facts and circumstances would not add up to reasonable standards. And some would, but let's make the case and decide.
And absolutely. And Suzanne's talking about Minnesota Statute 145-682 and the affidavit that you have to bring forward from your experts outlining their reasoning for and rationale for the case. That is a nation-leading law that's been in place in Minnesota since 1986. It's been cited by the General Accounting Office as one of the few things that have actually helped control medical malpractice insurance rates, and we have the lowest malpractice rates in the country in Minnesota. I put another bill up on the screen because I want you to know that, well, the bill we're talking about is what I'll call the full Monty. It protects everybody from everything. There is a bill that just protects healthcare workers and long-term care facilities and assisted living facility employees and companies, and that's Senate File 512. And I want to make sure that you know that there's a fallback position for them. If we can't get it for everybody, let's just get it for the ones that those of us on this call are most concerned about. So there is a fallback position for them, and I wanted to make sure you're aware of that. The issue is a legislative grant of immunity that takes away our right to remedy and our right to a trial by jury. 512 does it just as bad. It's just limited to healthcare providers. And I wanted to make sure that we remember that, because when you're talking to legislators about immunity, it comes in a lot of different forms, and not just the one that we kind of went through it with more detail. There are other ones out there that are equally as bad.
So I have a question about the politics of this, which is, I would assume, I hope I'm right, that this would never pass the House. Democrats in the House aren't going to support this. Is that a fair assumption? And if so, is there a risk that this could rear its ugly head in an omnibus bill down the road with a whole lot of other stuff?
Sure.
Absolutely. I am an extremely vigilant lobbyist. It's a little hard right now during COVID. I haven't set foot in the Capitol since the 13th of March of 2020 because it's closed. But I can tell you, we operate 4 screens a day. We watch every committee. We talk to every legislator we can to prevent that very thing from happening. I do think this is ripe for a conference committee and a final negotiation. The healthcare providers and others have been asking the governor to do this by executive order. He's certainly been made well aware of it, and he's rejected those efforts. But this is something they've been pushing on it since the start of the pandemic. And I think until May 17th and the legislative session is adjourned, I think we're on notice that this could pop up at any point. They don't care about the process. They want this bill passed. And so we need to be vigilant. I don't think Speaker Hortman or Majority Leader Winkler would in any way negotiate to allow this to happen, but you never say never. And so we're watching it at every step.
Couple more questions have popped up in the chat. One is, what about the staff who refuse to get the vaccine and then interact with the residents and their right, to care for them? Where does that leave us? Can either of you chat about that?
I know that Suzanne's probably in a better spot to answer this than me. The only thing that I would say on that is, allowing someone who is knowingly transmitting COVID, I think is an irresponsibility for the employer, and that they should be subject to that. If they're not taking employee temperatures and doing the things to have their own employees be healthful, that's a problem. They can require that their employees get the vaccination, and they can take employment-related action against an employee if they don't get the vaccination. So no one has really put that exact question to me, But I do know that employers can require the vaccination and can take action if they don't.
The only other thing I would add in talking with long-term care providers, there are a not insignificant number of those in the workforce in the long-term care community that are under the age of 16 or in the 16 to 18 category. So the age is at least a factor in some of the employees not getting a vaccine.
If we could go to, first of all, thank you, Joel Mullery, for reiterating and supporting exactly what Joel is saying, and the importance of getting out and talking to legislators, because they've got a lot of bills and often don't have time to thoroughly understand these bills. Also, Linda's asked, is there an expiration date?
There is not.
There's
It
not.
starts March 13th and there is no end date.
Yeah, okay. And then what about the future pandemics and the precedents this sets for us?
I think in that capacity, they, because it's written related to COVID-19, with the next pandemic, it may not apply, but that's just merely changing and adding the latest variation of a virus to an existing law. We don't want this in statute in any way. I see another question here from Mike. I don't have myself a sample letter, but I do think that Elder Voices has been communicating. I know that ARP has been sending letters, and if there's a way to push that out to Elder Voices membership or their email list, I'm sure that that Chris and others can help get that out.
Yes, and Mike, we have a position statement that we've sent, and I'll make sure that you get that as well. And you could use that position statement to send along with your request that that legislator oppose this legislation. It's always good to personalize your message if you've got experience that is relevant to this area, and obviously let them know you're a constituent. You're the person they care most about because you vote. And I know that's common knowledge for some, but might not be for others. And to Kate's question, who are the most effective people to involve in stopping this bill from the general public? I guess I'll let Joel respond, but you, the constituents, are the most important. Reaching out to the legislators, each needs to know that. But go ahead, Joel.
Yeah, my answer to that is the very people on this call are the most effective people in helping to stop this. But I'll expand that question a little bit more, or expand on the question, because part of it, who are the most effective from the general public? And in addition to voters, which are the very top of the food chain as far as we're concerned, people that are believable on healthcare issues from focus groups that we've done. Nurses are highly effective communicators on health-related issues. And so, we've got the Nurses Association that are actively working against these immunity bills, and we want to keep that going because it takes away their rights as well. There have been a number of complaints, not so much in Minnesota, but in other states where providers weren't providing appropriate PPE, and people were exposed. And there have been a number of cases from nurses themselves to try and get appropriate medical supplies and equipment. Those would all be banned under 745 as well. And so the nurses have been very active. They're good spokesmen, but not as good as voters. You guys are the best.
Well, and you just gave me an opportunity, Joel, to put a big thank you into our nurse members, because they have contributed immensely to our understanding of how some of these practices either help or harm people. And so thank you to them. Would it make a difference if assisted living were licensed? I have an opinion, but I'll let Susie.
The answer is yes, in my opinion. Currently, as you're aware, assisted living is not a licensed entity in Minnesota. We're the last state in the country to have a license of the assisted living. We do have the home care company that is licensed that goes into the housing unit that you know of as an assisted living. And so there is licensed home care coming in and providing the services. But what has occurred then is when you have CMS giving guidance to nursing homes in many states, that guidance is then filtering to assisted living. But in Minnesota, we do not have the regulatory regime, I guess, if you will, system in place to be able to go in. And while they have gone in to look at infection control in assisted living from the Minnesota Department of Health, we really have lacked some ability to be directly involved in many ways in the assisted living. So,
A question here has come about AARP. Have they opposed, and other organizations? Yes, they have opposed, and they do have a statement out there. I know as Joel mentioned, the Nurses Association has opposed, and the union groups are concerned because of protections for their employees. But Susie or Joel, others that you want to mention there?
I wish it was a larger group, Chris, but it is often tough. It's easy for groups that don't necessarily like it to allow others to do the heavy lifting, and I think that's unfair because they may want a legislator's vote on something else, and if I don't have to get my hands dirty, even though I don't want it, I'm not going to weigh in on it. We've gotten some help from Legal Aid and their Elder Law Center. ARP has certainly weighed in with the governor on the executive order. Your group, of course, has been a leader in the push and has actually pulled people together to make sure that we are all unified in our opposition to this. The healthcare bill that I put up on the screen was actually introduced in the 2020 regular session, and there was a hearing on it. It didn't advance in the Senate, and thankfully so. But that just gives you an idea that this is an issue that isn't going to go away. Every time there's a crisis, the business community and others come to the Capitol to seek this, from 9/11 to you name it, flood, Katrina. I mean, it's always an opportunity for them to insulate themselves by government action for their misconduct, and we watch it all the time. So,
I would just call people's attention to the chat. Elon has just put a link into a very, very powerful piece that he has put together on the issues regarding the care, and especially during COVID. Thanks for posting that, Elon. Any last minute questions that people want to, before we have to sign off?
I'll make one last pitch. The legislature at 5 o'clock today goes on their traditional holiday break for Easter and Passover, and I hope you all have a good break and holiday as well. This is a good time to be contacting them. They're not at the Capitol. They're back in their home districts, and this is a good time to be contacting legislators between now and April 6th when they come back to the Capitol.
Good reminder. Well, with that, thank you, Joel and Susie. You have done a fabulous job for us, and this is being recorded and it will be posted. So please let friends and family know they can come and view this excellent presentation in the future. Thank you to everybody for your kind attention and interest in this important issue. With that, I will say goodbye and have a very nice holiday to all of you.
Thank you.
Bye-bye.